नमस्कार और बहुत बहुत धन्यवाद। हम ये बार बार वी आर रिपीटिंग दिस पॉक्सो एक्ट एक्सरसाइज आई थिंक ट्वाइस अ मंथ, और मैं आज सबसे पहले आप लोगों का ध्यान लाना चाहूंगी हमारे आज की न्यूज के एक मेन आर्टिकल में, where a 16-year-old out with boyfriend gang raped at Rohini Park. So Delhi has become the hub of these sexual assault cases, and uh, this is the news where 16 years old minor girl along with her boyfriend who was 20 years old was found at 1:30 a.m. in a park to be having sexual relations. The boyfriend was also there. 6 other students, out of which 2 were adults and 2 were minor, entered along with 2 other minors, entered the park, hit the boyfriend of the girl, sent him out, and gang raped that 16 years old girl. She was left alone. Once the suspects left the park, she called a person to help her. Police was informed. Police reached the place, and she was not in a state to give the statement. Later on, she gave the statement in detail, as well as she could identify one of the suspects. So this is becoming the story day in, day out. It is a pervasive and a serious problem in India, and one that continues to grow every year. In fact, according to recent statistics, over 90% of Indian children experience some form of abuse before they reach the age of 18. This is a grave statistics and one that demands our attention. This I am talking of the latest one, that is February 2023. As a result of increased awareness, the number of such cases reported has more than doubled. Stopping child sexual abuse is essential. The Indian community should make concerted efforts to stop child sexual abuse in the country. It is not only the responsibility of the government to keep children safe and secure, but it is also the responsibility of all of us to ensure a safe and protected environment for our children, to enable them to live with dignity and free from any form of violence. The child sexual abuse defined by WHO is the involvement of a child in sexual activity that he or she does not fully comprehend and is unable to give informed consent to, or for which the child is not developmentally prepared, or else that violates the laws or social taboos of the society. The child sexual abuse includes different activities like intercourse, attempted intercourse, orogenital contact, fondling of genitals directly or indirectly through clothing, exhibitionism, or showing children to adult sexual activity or pornography, and child use for prostitution or pornography. Keeping all these things into mind and the rising cases of child abuse, the government of India enacted the Prevention of Children from Sexual Assault Offences, that is POCSO Act, in 2012 on 14th November 2012. It is a special comprehensive law to provide strong legal framework for the protection of children from offences of sexual assault, sexual harassment, and pornography. The Act safeguards the interest of the child at every stage of the judicial process by incorporating child-friendly mechanisms for reporting, recording of evidence, investigation, and speedy trial of offences through designated special codes. Now, as per POCSO, what is a sexual assault? According to Section 7 of the Act, whoever with the bad intention touches the private parts of a child, be it a male or a female child, or makes the child to do so, or does any act with sexual intent and which involves physical contact even without penetration, is said to be committing sexual assault. Punishment being not less than 3 years or may also extend to 5 years with or without fine. Section 9. Aggravated sexual assault means sexual assault committed by police officer, public servant, manager of a hospital, or an institution of a child. Now, what is sexual harassment? So 3 points are there: sexual assault, sexual harassment, and pornography. So under section 11, even when any person with a sexual intent utters a word or makes any sound or gesture or displays or exposes any part of the body with an intention that the child would hear the sound or sees the part of the body is said to commit the offense of sexual harassment. Even showing of any porn film with any sexual intention too is an offense. Using a child for pornographic purpose is also an offense punishable under the Act. Under section 16, instigation or facilitation or by willful misinterpretation or by willful concealment of a material fact of a child to do an act with a sexual intention is also the abatement of the offense of sexual act. The important provisions of the act is the definition of the child, definition of different forms of sexual abuse, including penetrative, non-penetrative assault, and what constitutes to be an aggravated sexual assault, the prescribed punishment under the relevant section thereof, sexual assault by a group and relevant punishment. Today, it was the case in the newspaper is a gang rape, that is rape by a group of persons. The mandatory reporting of the crime, the abatement of an offense under the Act would also attract the same punishment as the offense committed. The Act prescribes stringent punishment as per the gravity of the offense, with a maximum term of rigorous imprisonment for life and fine. Means whole life there can be an imprisonment. Further, the reporting of sexual offenses is mandatory by a person who has knowledge that a child has been sexually abused. If he or she fails to compliance, she may be punished 6 months imprisonment and or fine. Now, POCSO Act is a special act. Why? Because it asks to trust children and places the onus on the accused to prove the innocence. When a person is prosecuted for committing or abetting or attempting to commit sexual offense, the special court presumes the same unless the contrary is proved. The court presumes culpable mental state, that is intention, motive, etc. of the accused. The law ensures that the pressure is not on the child to prove that the crime took place. It is a gender neutral law. POCSO Act ensures punishment for all perpetrators irrespective of age and gender. By defining child as any person below the age of 18 years, the Act sets a gender neutral tone. Consequently, a child of any gender who has been sexually wronged has access to the remedies provided under the Act. The Act also does not distinguish between perpetrators and the ground of gender, and there have been instances where the courts have convicted women for such an abuse. Secondly, no time limit for reporting the abuse. We all have been listening, witnessing, and hearing about the WFI president recently, who has been charged by a minor for sexual harassment under POCSO Act. Of course, she withdrew her complaint and police could not find any corroborative evidence, so the case has been cancelled. But the hearing of the case is again on 1st of July. What the court decision is depends whether the police has properly investigated the case or not. So this was this case was before the action which has happened 10 years 9 to 10 years before, that is way back in 2014. So there is no time limit for reporting abuse. Why? The trauma that child sexual abuse victims endure prevents them from voicing their complaints immediately. In 2018, the Union Ministry of Law and Justice clarified that there is no time or age bar for reporting sexual offences under the POCSO Act. Consequently, a victim can report an offence at any time, even a number of years after the abuse has been committed. Therefore, organizations dealing with children in India cannot shun child sexual abuse complaints raised against their employees on the pretext of lapse of time. Maintaining confidentiality of the victim's identity. Disclosing or publishing the identity of the child victim by mentioning the name, address, school name, and other particulars is punishable with an imprisonment of not less than 6 months but extendable to 1 year with fine or with both. This prohibits making of negative report that cause harm to the child's reputation. In today's case also, in the newspaper, there is no name of the girl because she is a minor. There is no name of the two boys who were involved in the sexual assault because they are minor, and no name of the two boys who witnessed the activity because they are minor. Now, again, there is no discretionary jurisdiction. Courts cannot exercise their discretionary powers in POCSO cases. They cannot reduce the term of imprisonment to a term less than the minimum term stipulated under the Act. Now comes a very important part of the Act, that is also called as the flagship feature of the POCSO Act. Under Section 21 1 of the POCSO Act, there is the need of mandatory reporting of cases of child sexual abuse to the law enforcement authorities, and applies to everyone, including parents, doctors, and school personnel. Failure to report a suspicion of child abuse in an offense under the Act, the legislation makes it clear that reporting obligation exists whether the information was acquired through the discharge of professional duties or within a confidential relationship. Any private person who fails to report suspected child abuse, having acquired the information in the discharge of his or her professional responsibilities, commits a summary conviction offense. Now, why there is a need of mandatory reporting? The purpose of reporting is to identify children suspected to be victims of sexual abuse and to prevent them from coming to further harm. What to report? Explain as well as you can what happened or is happening to the child. Be prepared to give the name, address, and the telephone number of the child, and also the name of the parent or caretaker if known to the police only. However, the reporter is not expected to investigate the matter, to know the legal definitions of child abuse and neglect, or even know the name of the perpetrator. Then question arises, how to report? Any person who has apprehension that an offense is likely to be committed or has been committed should provide the information to the Special Juvenile Police Unit, SJPU, or local police. The police or SJPU should make immediate arrangements to give the child care and protection. They should report the matter to the CWC within 24 hours of recording the complaint. Steps should be taken to admit the child into shelter home or to the nearest hospital within 24 hours of the report. No person should incur the liability, either civil or criminal, for reporting the commission of the offense. The POCSO Act 2012 makes it an offense to report false information when such report is made other than in good faith. So, what are the main key stakeholders under POCSO Act 2012? One, parents of the child. Secondly, Special Juvenile Police Unit. Thirdly, medical professionals. And fourthly, Child Welfare Committee. So, when we talk about the Act in toto, we discuss the role and responsibilities of every person. What the document published by the Government of India has divided the act into divided the responsibility to complete the act into 4 parts, that is role and responsibility of parents, role and responsibility of police, role and responsibility of medical professionals, and role and responsibility of child welfare committee. So today we will discuss in detail about the role and responsibility of medical professional in case of a child sexual abuse, and I'll request Dr. Renu Chawla to discuss the part 2 of today's talk, that is role and responsibility of medical professionals or gynecologists in case of a child sexual abuse.
Dr. Sangeeta, and thank you, ma'am, for giving us this opportunity.
Should I close my presentation?
No, ma'am, आप ही इसी को चलने दीजिए, and you only have to change the slides. Next. Role of medical professionals in POCSO Act 2012. Doctors have a dual role to play in terms of the POCSO Act 2012. They are in a position to detect that a child has been or is being abused. For example, if the child has been brought by her parents or she has come herself to the medical professional, but you suspect some foul play has been there, so you have to ask her directly that what has gone wrong with her. because they may not have lodged any complaint, or she may not have told anybody. So as Dr. Sangeeta has already pointed out, that there is no time limit for reporting such a case. So we should ask her in detail, we should examine her in detail, so that this kind of a act does not go unnoticed. They are also often the first point of reference in confirming that the child has indeed been the victim of sexual abuse. The role of the doctor also includes emergency medical care of the child, having in-depth understanding of sexual victimization, obtaining a medical history of the child's experience in a facilitating, non-judgmental and empathetic manner, meticulously documenting historical details, conducting a detailed examination to diagnose acute and chronic residual trauma and STDs, and forensic evidence if possible. Considering the differential diagnosis of behavioral complaints and physical signs that may mimic sexual abuse, obtaining photographic video documentation of all diagnostic findings that appear to be residual of such an abuse, formulating a complete and thorough medical report with diagnosis and recommendations for treatment, testifying in court when required.
प्लीज बाकी लोग म्यूट कर चले जाएं प्लीज, बहुत इको आ रही है.
Medical examination of a child even before an FIR or a complaint is registered, and it is not mandatory that we should force the victim to lodge an FIR. Even the MLC, if it has been made, the duty of the doctor is over. We have to make an MLC and hand it over to the proper authorities, so that our part is covered under that. We may not be able, we should not force the parents or the child to have FIR lodged. If they want to do so, they can do it. If they do not want to do so, at least MLC should be made. Even before an FIR or a complaint is registered by a government doctor in a government hospital or a hospital run by a local authority, if a government doctor is not available, the examination can be conducted by any other registered medical practitioner with the consent of the child or of a person competent to give consent on behalf of the child, in the presence of the parent of the child or any other person in whom the child reposes trust or confidence. If suppose the child is not comfortable with the parents, then she should be asked whom she wants to be with her when she discloses her sequence of events. It is not mandatory that she should do this in front of her parents only. Maybe one of them is the culprit. So we have to give liberty to the child so as to choose with whom she is comfortable with. Within 24 hours from the time receiving information about the offense, we should make it sure that it is reported. In case the victim is a girl child, the medical examination shall be conducted by a female doctor. For any reason, the parent of the child or other person referred to in subsection 3 could not be present, the head of the medical institution will nominate a woman, and the medical examination shall be conducted in the presence of that woman. The doctor shall forward the report to the investigation officer without any delay, who shall forward it to the magistrate. Consent of the victim is important. A child victim and family may approach a health facility under 3 circumstances, and informed consent must be taken in all. On his or her own, only for treatment for effects of assault, or they may come with a police requisition after the police complaint. And thirdly, when a court directs medical examination of a survivor victim of sexual violence, cannot be conducted against her consent. So her consent is very, very important. Unless and until she gives consent, we should not force her for examination. No court or person can force a medical examination on a person who denies for it. Minimum age of survivor for giving valid consent for medical examination is 12 years. In case of a child below 12 years of age, whenever parents and or guardians are not available, consent can be obtained from a panel of senior doctors in administrative positions in the hospital. Consent may be asked for the following purposes. There are 3 main purposes for which a consent is taken. First is the examination. Then is the sample collection for clinical and forensic examination. Then treatment and police intimation. Consent should be informed. This information should be given before the examination is conducted in a in a form, language, and manner that the child and his parents or guardian can understand. The right to informed consent implies the right to informed refusal. But if there is refusal, we should take it in, we should document it. It should be taken in written. But after making the consent examination to be conducted in the presence of a person trusted by the child, for example, parent, relative, or social worker, in the absence of which a woman nominated by the hospital needs to be present during examination, police personnel should not be present during any part of the examination. If they are present, they should not be in the uniform. They should be in the civil dresses because the child may get frightened by the presence of police if they are in their uniform. Sedation for medical treatment. Consider sedation or a general anesthetic only if the child refuses the examination and conditions requiring medical attention such as bleeding or a foreign body are suspected. Collection, preservation of evidence. Collection and preservation of evidence using the safe kit. Safe kit we all know and its contents all of us should know. In case there is no specified safe kit present in any of the institutions where the patient has been brought, then it can be assembled very easily because it does not contain things which cannot be assembled in a short notice. So, preferable is that the safe kit should be there. In case it is not there, it is not a big deal. It should be assembled there and then. Do a thorough medical and forensic examination. Valuable evidence is lost after repeated examinations. Preserve the clothes and other relevant material that the child was wearing at the time of the incident. Collect materials, swabs, and samples for DNA profiling for forensic evidence from hair, nail, body surfaces, or orifices. Any product of conception before washing, cleaning, before the child urinates or defecates, all the samples should be collected. Collect the blood samples for intoxicants and blood group. And if the products of conception are collected, they should be washed with saline and then they should be collected in a sterile container with a wide mouth and a lid. It is very, very important to collect the sample properly so that the tests which are required can be done on it, and it should be handed over to the police. When the products of conception are collected, they should be collected first of all properly and should be handed over to the person who are supposed to be given the authority of collecting them. Referral and counseling. Whenever it is felt the need for counseling for testing of HIV and other sexually transmitted diseases, then the child may be referred to the concerned center. Mandatory reporting. When doctor suspects that a child has been or is being sexually abused, even in the absence of consent of the child or parents, have mandatory legal obligations to report sexual assault on the child cases to the appropriate authorities, the police or the relevant person within his organization. If he fails to do so, he may be liable for punishment of imprisonment of up to 6 months with or without fine. When a doctor has reason to suspect, it is the same which I have already said. Expert witnesses, before giving evidence in the court, the expert will have to prepare a report based upon the history, statements of child, and thereafter medical examination can give conclusive opinions regarding sexual abuse. The physician cannot make definitive conclusions as medical expert treat or examine the child can appropriately conclude that whether there is evidence of recent sexual contact, any recent injury, and the history and medical examination are consistent with sexual abuse. Collection and preservation of evidence.
We have already discussed.
We already discussed. Next. So conclusion. The POCSO Act 2012 is certainly a law which was need of the hour because it is now very much helpful to prevent sexual assault against a child. As we've seen that yesterday itself, the same thing has happened. The provisions of law provide full privacy to victim for medical examination and collection of forensic evidence samples. The time frame prescribed for the medical examination and reporting is pivotal, along with mandatory to reporting by a doctor wherever they encounter the case of child sexual abuse. The effective implementation of the POCSO Act would be a great tool in delivering of justice to the victim and punishment to culprits. This is the same thing.